Good morning. Are you Edgar Castillo?
Good morning, yes, ma'am.
And Mr. Gertz, will your client waive the formal reading of the indictment?
He will, Judge.
Mr. Castillo, in clause number 25, DCCR 1052, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle, and that's from March 23rd of 2025. And how do you plead to that charge?
Nope. Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Gertz?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 2-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Castillo is not competent?
No, Judge.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to restate your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back at another date for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. So just stop on your way out, and we'll see you back at sentencing. All right, good to go. Thank you. All right, good morning, sir. You Stovall.
Yes, Your Honor.
And this is cause number 25, DCCR 1872. Mr. Stovall is charged with violating a protective order. And Mr. Gertz has filed a motion to quash the indictment. I've obviously reviewed that motion. Mr. Coleman has filed a response or a reply to that motion, and we're here today on that. I've done obviously some of my own research as well.
I filed a reply to Mr.
A reply to the reply.
Agent.
Oh, just a second, I didn't see that come through.
It's short. It will take you 2 seconds to review it, I would suspect. Hyperbolically, of course. Even honestly, I have attention. Congratulations. Thank you.
So 1338 has been repealed.
That's my understanding, Judge.
Yeah,
I think
Judge,
the applicable statute is 13A.203.
I think that's correct. If you actually read the language of my original motion, I say that it used to be this, it's now been changed to this, and they mean exactly the same thing. The reason I point that out, Judge, is that the legislature recently revisited venue on this statute and chose not to add where the complainant resides as one of the options. And so that's why I was pointing out what the old statute said and what the new statute says. That's all.
So the new statute is what?
It reads almost identical. It's
13.
13A.203.
Thank you.
I cited both.
Okay. Getting there, just give me a second. I want to look at everything real quick. The indictment in the style is 25072, but it should be 25071, I believe. Well, I mean, that's not, it's violation of a protective order, correct?
It has to be multiple to be a felony, and that's
Well,
what gets us to 7-2, I believe.
7-2 is repeated violation of certain court orders or conditions. 7-1 is violation of a protective order.
Right. I think they may have kind of pled it as hybrid, but they're talking about 02.
I would concede and agree that it should be 02, Judge.
Okay, so it says 02. That's correct then. All right. Okay. So with regard then to the new 13A 203, this is not a protective order,
It is a protective order,
but
Judge.
the indictment alleges violating a condition of a bond.
I will again concede error on the state's part, and that could be remedied, as I put in my reply, simply by amending the indictment.
Well, I think that probably should have been done because I
didn't want to amend it until I got the court's ruling on the other issue, the issue of venue.
but that matters. So, okay, so let's do it this way. If it's a protective order specifically, then 13A 203 appears to be specifically on point. So what's the state's position with regard to that? Because it says specifically what the venue is.
Well, my understanding of 13A.203 is that either it can be prosecuted where the protective order was issued or where the offense, quote unquote, was committed. Certainly, we're not seeking to prosecute it in Travis County where it was issued. The fallback would be where the offense is committed. And since statute is silent in the regard as to whether or not it can be venues proper where the complainant resides, I cited cases that I thought were instructive for the court, Your Honor. In other words, an issue here is the offending communication that was sent, electronic communication allegedly sent by this defendant that violated the protective order. And I think the cases that speak to either obscene or harassing communication that we've cited in my reply, it speaks to venue. In fact, the 14th Court of Houston that cites a Court of Criminal Appeals opinion, it specifically says, with regard to an obscene communication, the venue is proper where the applicant or the victim resides. And as it relates to an obscene telephone communication, that's in the an appellate court out of Austin, 1991, that's cited in my reply. It says, with regard to that telephone communication, that venue is proper where the victim resides as well. So again, in construing 13A.203, I think those instances are they're instructive for the court to interpret that statute in the absence of more specific language that could have been or should have been provided by the legislature. And I'll just end with this, Judge. To rule otherwise would render, in my opinion, an absurd result in that a victim would have to travel to wherever this defendant may have made the offending communication, be it on a laptop, somewhere in another part of the state, or maybe even outside of the state, Judge. So I just think that in this day and age of cell phones and mobile digital devices, that it's more appropriate for the venue to reside where the defendant received the communication.
Mr. Gertz?
Judge, multiple things that Mr. Coleman said I think are incorrect. First and foremost, the case that he's citing is from 1993. It is pre-social media. It's almost pre-cell phones. The case that he cites too, if you actually read the facts of the case, the person was found guilty of a variety of different harassing communications.
Let's go to what I've looked up and what I've found, so I tend to agree. I mean, the Article 13A 203 does not say that it's where the defendant is. It says where the offense is committed.
Right.
And so the research to me is around offense being committed, what that means, not where he is, where she is. It doesn't say either of those things. So I don't think there's an automatic argument that it has to be where he is. There is Solis v. State, which is a 2003 case, specifically says venue's proper if there's substantial contacts with the prosecuting county that has some relationship either to the defendant, his conduct, his victim, or the fruits of his crime. There's many cases that also say the same thing. There is that this is actually a Torres case. The one that I was reading from is a 2023 case that cites that Solis case from 2003. And so I think the same result that in these types of cases, because of electronic communication, to have to say, we don't know for certain and can't know for certain where either of them were when they were on their phone or whatever they were on doing, either sending or receiving. And so I don't think it should be limited. I think it is a jury question.
May I be heard on that though, Judge?
Sure.
The default position, and the code gives you a default position. The default position is if it cannot be readily determined by the facts, then it goes back to the three other options, which are where he was arrested, which was Travis County, where he lives, which is Travis County. I mean, Mr. Coleman used the word gravamen of the gravamen of the venue statute is about him, not about the complainant. And
but
so
if it can't be determined from the facts, I'm not doing, that's a jury question, is to determine the facts. I don't think that me determining that is necessarily, I think that would put me in a position where I would put myself in the position of the jury in something that's not necessarily as clear as some indictments where a quash would be potentially granted.
Nathan, I'd be heard just on one other issue.
Yes, sir.
Mr. Coleman raised. So he said that would render an absurd result if we followed the venue statute narrowly. I would suggest to you that it actually renders an absurd result if we follow it the way the state is proposing. Here's why. What it would allow any complainant to do is go to a really favorable county where the police like that person and the judge likes that person and whatever, and then open their Facebook and say, oh, man, I read it in Jasper County and everybody likes me in Jasper County. Let's bring him who's never been to Jasper County.
Well, is that
here.
the allegation about the complaining witness in this case? Did she come here and do that?
I think
is that what the allegation?
Home to her family's house, but he's never lived here. He's not been a resident here.
But she has that tie here. She didn't just show up.
I understand, but he's talking about it rendering an absurd result, and I'm saying it's the exact opposite. The venue statute is about whether he has to be hailed in front of a jury for which he has not made his own sufficient ties. It's not about the complainant's ties.
Except that it is sometimes, specifically. No, but the Court of Criminal Appeals has found now several times, Court of Appeals cases and Court of Criminal Appeals cases, that venue is proper in a multitude of places. And so based on that, I think this one is not something that is as black and white as I think you're making it sound, or your perception is. I think that it would create the potential for someone to be able to say, I wasn't there when I said, I mean, everything is, so the movement of everyone with computers and phones, I don't think it should be restricted in this case based on what I know and not what I know about the case, what the indictment alleges with regard to the communications being received by the complaining witness in Jefferson County. And that the case law specifically says that venue could be appropriate in a county where the victim is, where the fruits of the crime were, or where the conduct affected someone in that jurisdiction. So based on that, I'm going to deny the motion to quash. We'll reset the case for an announcement. Go ahead.
I'll get the indictment amended.
Okay.
Protective order versus bond.
That's fine. We won't have any objection to that.
Okay.
Judge, as it should be obvious from all the filings, my client lives in Austin. And so what I'd ask, I don't anticipate there's going to be an offer from Mr. Coleman that my client's going to accept. I don't know if you want to do one announcement and then we can put it on the trial docket at that point.
Yeah, I mean, unless y'all have already negotiated and received everything and gotten an offer, I'm just going to do a normal reset, and you can reject any offer at that time if there's a rejection, and then we'll get it set for trial after that. All right?
Thank you, Judge.
Pretty good.
Thanks, Judge.
Good morning. Are you Felicia Freddy? Speak up loud and clear so I can hear you, and so the court reporter.
Yes, ma'am.
Please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. You can put your hand down. Will your client waive the formal reading of the motion?
She will, Judge.
Ms. Freddy, in clause number 24, DCCR 1390, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation June 23rd of 2025 for the third-degree felony offense of evading arrest or detention with the use of a vehicle, and that was a 2-year deferred probation. Is that correct?
Yes.
Judge, I think there is an error there. I just realized. I think she was placed on misdemeanor eluding probation, not felony.
I think he may be right, Judge. Let me verify that.
I'll put it since.
We got to put this down, is my recollection, Judge.
My notes in the file indicates that it was a lesser included fleeing or attempted to elude back on June the 23rd of 2025.
Is that a Class A or B?
Eluding is typically B, isn't it?
Looking at.
I'm not sure, Judge.
If I had a second, Judge, I could.
Here, I'll look at the end.
Mrs. B.
The papers. A. Of that motion, so I can run it. So would the state like to orally amend the motion to revoke?
Yes, Judge. To reflect what was actually played to the lesser included.
Any objection to that?
I don't mind the court amending that motion, Judge. It's probably not what you asked me. I don't object. How about that?
That's good, thank you. Okay, so let's go back. It looks like then in that motion to revoke now as amended, that you were placed on probation for the lesser offense of eluding arrest or detention, Class A misdemeanor, and that was a 2-year deferred probation. Is that correct?
Yes.
The motion alleges that you violated your probation. Count 1 alleges that you committed the offense. So 2, it's resisting arrest, search, or transport, and a silent abusive call to 911 on November 25th of 2025. And is that true or not true? Count 2 alleges that you failed to dress appropriately and conduct yourself in a courteous and professional manner, especially when interacting with court officers, staff, probation, or law enforcement officers. Is that true or not true?
True.
All right, so I'm going to enter pleas of not true to counts 1 and 2. We'll get an updated pre-sentence report and we will set this for a hearing. Mr. Coleman, is this something with regard to witnesses that we would need maybe a little more time?
Just a little more.
Then at 11 o'clock, we'll do it on a separate day.
No.
So stop and talk to probation on your way out here of the courtroom. We'll reset this for a sentencing hearing. Anything that you think is important, obviously for me to know, get with Mr. Gertz, and then we'll have that hearing on that date. Okay? All right, you're free to go. Good morning, sir. Are you Remington Boykin?
Yes.
And will your client waive the formal reading of the indictment?
Yes, Judge.
Mr. Boykin, in cause number 25, DCCR 0396, you're charged with the state jail felony offense of tampering with a governmental record, and that's from August 12th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please.
loud.
Yeah, yes, sorry.
And are you pleading guilty because you actually did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Gertz?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 2-year deferred probation. There would be a fine of $500 and restitution ordered in the amount of $3,125. Is that your understanding?
Yes.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
We have no objection, Judge.
It's admitted. Is there any evidence that Mr. Boykin's not competent?
None at all, Judge.
What's the position with, since you have restitution? It's a
Judge, we know the restitution amount. I believe he has cases pending in other counties, but I don't think he has any prior convictions. I show no other criminal history pending prior to this, so I don't have a problem going forward today.
Okay.
And we agree to waive, Judge.
Okay, thank you. So at this time, Mr. Boykin, I'm going to waive the pre-sentence report. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years. You're ordered to pay the $500 fine and restitution in the amount of $3,125 and to follow all of the rules and conditions of probation. If you do everything you're supposed to on this probation, this is an excellent opportunity because you don't have a felony conviction on your record. And at the end of the probation period, if you're successful, the case will actually be dismissed. You'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you could be brought back into court, found guilty of the offense, and sent to the state jail prison for between 6 months and up to 2 years. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. Do y'all have the discovery certification?
Sign that now, please.
You'll need to have a seat. After you sign that, have a seat here in the courtroom. Probation's in that desk right there behind you, and she'll call you up when she's ready to go over your paperwork. You can go ahead and have a seat, sir.
Thank you.
Just watch for her to call your name.
Yes, ma'am.
Thank you, Your Honor.
Thank you.
I didn't realize that on the
That's a big issue on that other one. Good morning. You are Alexandria De Leon. And this is cause number 26 DCCR 0143. Ms. De Leon is charged with assault on a peace officer. And what is the announcement?
Your Honor, we'd like to reset. Ms. De Leon has some contractual obligations. She still needs to meet with my office. We've received everything from the district attorney's office. I've been in contact with the district attorney. I think this is going to be a case that we're able to resolve. We'd like to come back in August if that's possible, Your Honor.
We'll just do a normal reset.
Perfect.
Which is about 30 days, and then we'll see where we are at that point. I know you were just hired last month, so
Yes, ma'am.
I mean, I'll give you some leeway, but let's see where we get in 30 days. Ms. De Leon, make sure you stay in touch with Mr. Nick, visit with him about your case, take care of everything you need to. We'll see where we are at that next court date.
Thank you,
Right,
Judge.
pretty good. Morning, sir. You Blaine Dunnigan? And will your client waive the formal reading of the indictment?
You will, Judge.
See, Mr. Dunnigan, in clause number 25, DCCR 0566, you're charged with the 3rd-degree felony offense of driving while intoxicated, third or more, and that's from April 9th of 2023. The indictment alleges you were previously convicted of driving while intoxicated November 3rd of 2016, and after that was final, you were convicted July 6th of 2020. And how do you plead to that charge?
Yes.
And are those 2 prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they've charged you
Yes,
with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Gertz?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like that agreement is for a 10-year term in prison, but that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law.
Yes, ma'am.
State tenders number one,
I have no objection, Judge.
it's admitted. Is there any evidence that Mr. Dunnigan's not competent?
None at all, Judge.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll just give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's at that desk right there.
Yes, ma'am.
All right, we'll see you back at sentencing.
Thank you, ma'am.
Good morning, sir. You're Dan Church.
Oh, yes, ma'am.
And this is 26 DCCR 0612. Mr. Church is charged with deadly conduct, discharging a firearm. And the state has filed a motion asking that well, I'm looking at the state's motion. The motion it says aggravated assault, but the charge is deadly conduct. That just
I'm sorry, Judge, that's my error. I was
Okay.
trying to file it rather quickly after receiving the affidavit from the complainant, and I'll fill the court in on that as to why I don't have a witness present.
It looks like the current bond is set at $20,000. The state has asked to raise that bond. Ms. Malfino?
Excuse me, Judge, and I apologize about that error. Obviously,
That's fine.
the court would see the probable cause affidavit. It's very similar to an aggravated assault, discharging the weapon somewhat in the direction of the complainant. In this case, I have had multiple conversations with Jeremy Shelton, the complainant. He is the across the street neighbor of Mr. Church. He is a very nice young man. He was very forthright, came in and presented me or had an affidavit authored by himself with one of my investigators. In lieu of coming to docket today, he, as the court can probably surmise, is of the mind that he doesn't want to aggravate the situation. No, not intending to use that same word, but I will tender that as State's Exhibit number 1 just for purposes of this hearing, and I have Mr. Gertz, it's his affidavit just expressing concern about the nature of this offense and the fact that they reside across the street from one another, that he has a very young son and a wife who were also present at the time of this offense, and he has concern that Mr. Church may be keeping weapons at his sister's house down the street. I have worked very closely with my investigator, Mr. Bays, and he is familiar with Mr. Church as well as Port Arthur Police Department is. We have asked that some things be implemented in the interim time period to hopefully assure the safety of all the parties, including Mr. Church. I just wanted to bring this matter to the court's attention with that motion. It's not necessarily intended to increase as much as it is to modify with the admonishment regarding weapons, etc., because obviously it's difficult to remove these two individuals from one another approximately because of where they both reside.
Any objection to me reviewing that?
Well, Judge, the rules of evidence don't apply in a bond hearing, so I would love to have some great evidence, but I don't have a good one.
And I'll state the ones admitted for purposes of this hearing. Give me just a second, please. Mr. Gertz?
Judge, I'm happy to discuss bond conditions. $20,000 is more than sufficient, though, in terms of the amount for this allegation as it stands right now, or as it's indicted right now. Mr. Church wouldn't, I think, object to the normal conditions of not having any contact with the complainant, not possessing any weapons.
Those are already conditioned.
Right. I'm not sure what else. What else the court could impose because of the proximity of their homes without infringing on his constitutional property rights of his own. But I think the fact that he's hired counsel, has shown up to court, he's taken this seriously. He's not been threatening the complainant or anything of that nature. I understand the complainant may have concerns, but those are the complainant's concerns. They're not being triggered by anything, no pun intended, by anything that Mr. Church has done since his arrest or his indictment. And so, and he's not violated any of his bond conditions that
No, I think
that I'm aware of, or that
is if they feel like he is watching, could be, just uncomfortable. There's an allegation that he's sitting in his car watching family, obviously based on the nature of the offense and the allegations and the probable cause. That would give me some concern too if I lived across the street and that had actually happened. So,
but I just don't think raising his bond and just charging him more penalty is the proper remedy for that. So I'm not sure how the court remedies that. And I don't see what
the way it gets remedied, Mr. Church, is if you're doing anything that's making the person uncomfortable, that's the complaining witness in this case, the only way for me to take care of that is to put you in jail. Then they don't have to, nobody has to worry. I don't want to do that, but I need you to understand that there's no way around if, you're not contacting them or talking to them. I get that. But if you're doing other things, like sitting in your car and watching them, then that's going to be of concern to me. So I'm ordering you, here's what I'm ordering right now. Listen to what I'm going to say very clearly, okay? This no contact order is going to include literally looking that direction. You can't sit on your front porch. You need to sit in the back. You can't just sit in your car for no good reason. People don't do that. So you're not going to do that. Do you understand? So if they feel uncomfortable, they're going to let Ms. Malfino know, and you're going to end up in jail. So I understand you live across the street, but if I were you, I'd walk. If I was going out my front door, get in your car and leave if you're going somewhere. No lingering, no looking that direction, no standing there watching. Otherwise, you're going to end up in jail because I won't have any other choice. Does that make sense? Okay. So we'll reset this for an announcement. Make sure you stay in touch with Mr. Gertz, visit with him before that next court date, and we'll see if we can get an announcement, okay? You're free to go.
Thank you.
Oh, here. One of those is just what I printed out. Do you want the exhibit or does that go on the bottom? Good morning. You are Amber Bruno Walker, and this is cause number 25, DCCR 1814. Ms. Bruno Walker was previously in court, entered a plea of guilty to the state jail felony offense of driving while intoxicated with a child passenger. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor.
The state has, Judge.
Are there any additions or corrections?
None from the defense, Your Honor.
No additions or corrections. However, I do have a comment or a question.
Sure.
And it relates to the defendant's version of page 2. Your Honor, I don't know that it's a full-throated admission of guilt. She refers to this incident as being a distracted driving incident, when in reality it was a rollover crash. She was essentially not cooperative and required a blood search warrant to get her blood.
I made note of that as well.
Judge, I would add to that, though, is, she did acknowledge in that same thing, although it's not lengthy, but they listed, she did also acknowledge in it that this was her responsibility. She said that's responsible for it.
I mean, you tested your blood alcohol by the time they finally got it was 0.0986. I mean, so you definitely were above the legal limit. Are you disputing that?
No.
Okay. So, Ms. Bruno Walker, at this time, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated with a child passenger. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but that will be probated on for 5 years. So you'll be on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. So you're going to be regularly tested. The police version is that it rolled over.
Yes, ma'am, it did.
It did not roll over. Okay, that's just a. So,
Just so the record's clear, Judge, I've got a photo here. I'll show it to Mr. Rennick as well.
okay. How's that not a rollover?
It's nothing to out.
I thought rollover mean like,
Well, it wasn't on all four wheels, was it?
Yeah.
While you had a child in there. So here's part of the important thing about probation is in order to be successful, you've got to completely take responsibility for everything you've done, all of the conditions that you're going to have to do. It gives me some concern that there's some diminishing of that by you right now. So it is very important that you take advantage of everything that you're about to have to do on probation, because if you don't, you're going to be right back in here and you're going to be looking at that 2-year sentence. You understand? So you are, do you currently have the auto ignition device on your vehicle?
yes, I do.
Okay, so you'll make sure and keep that. Obviously, if there's any blows into that are positive for alcohol, it's a violation of your probation. If there's any issue and probation feels like you need anything more than just regular probation, you'll immediately be referred to treatment, whatever that is. It will be ordered by the court. You understand? You can't have a single drink of alcohol while you're on probation. And obviously you can't do anything else, whether it's legal or illegal, without a prescription. If you do everything you're supposed to while you're on this probation, this is a great opportunity because you'll be able to serve that 2-year sentence that you received while you're out on probation instead. But the other side of that is if you violate any condition of probation, you can be brought back into court and you can be your probation revoked and facing that 2-year sentence. You understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rennick. All right, you just need to have a seat here in the courtroom. Yes, ma'am.
Occupational
Talk to your attorney about that. That's filed somewhere else separately from this. And so have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, ma'am. Thank you.
Thanks.
Good morning.
So this is Miss Malfino. Miss Malfino on Regina Williams. Good morning, ma'am. You're Regina Williams. And this is 26 DCCR 0218. And what is the announcement?
Your Honor, she's informed me has documentation that she's supposed to provide today, which I think will resolve the case if it says what she says it says, but I have not seen it. She told me she can have it today, and I'm asking for like a 2-week reset.
So why haven't you gotten that to Mr. Parker already?
Because the people didn't meet me to sign the affidavits at the notary, but they said that they'll meet me today.
Okay, so I'm going to do about 2-week reset.
Yes, ma'am.
Well, let's do this. I'll just do a normal reset, okay? Get that as quickly as you can to Mr. Parker because he needs to get it to Ms. Malfino so she can take a look at it, and then it may or may not make a difference in your case, but she'll take a look at it once that's done. If for some reason that doesn't happen, then when we come back, we'll need to do something to the case, okay?
And Judge, if I may, just to reiterate what the court said, based on her prior criminal history, it's not likely that that affidavit's going to suffice.
Okay.
But I'm happy to take a look at it, but I will make 2 alternative offers.
Okay, thank you. So make sure you visit with Mr. Parker before that next court date as well. Okay, thank you.
They say I have another one, but I don't have the bond. Yeah,
I don't have anything else.
Okay.
Good morning. You all right, Mr. Gray?
I can't have it, Bob.
You okay this morning? Why are you sleeping?
Work.
Work. Have a seat in the jury box. I'm gonna get you tested this morning to see if there's anything in your system. Mr. Lewis, you've got Treasurer Harris. It's a sentencing.
Second seat, back row.
Good morning, sir. You're Christopher Rhodes.
Yes, ma'am.
This is 26 DCCR 0209, and Mr. Rhodes is charged with driving while intoxicated with a child passenger. And what is the announcement?
We have an agreement, but they need to re-indict him. And so I think Malfino said a couple weeks or.
Judge, he provided the mitigation documentation this morning to allow me to re-indict this to an endangering from a UWI child passage
Okay.
so that he may receive deferred. I could have it indicted on Wednesday and be ready to plea sometime in the next 2 weeks.
All right, we'll just do about a 2-week reset. And Mr. Rhodes, make sure you stay in touch with Mr. Parker. He'll let you know when that next court date is, and we'll take care of it we'll put it on a plea docket on that next court date. All right, free to go.
Thank you.
Good morning, sir. You're Ryan Reamy. And this is cause number 25 DCCR 1246. Mr. Reamy is charged with driving while intoxicated with a child passenger. It looks like just recently there was a motion to suppress filed. Is that something, do you believe, Mr. Comerford, that would be dispositive of the outcome of the case if I hear it prior to trial?
Yes, Your Honor.
Okay, so let's do this. I'll set it for a hearing on that in the next 30 days or so. We'll find a time when we have a couple hours at the most. I wouldn't think it would take more than an hour or two.
Okay. I haven't looked at it, Judge, but
Okay. And then I'll go ahead and take care of that. That way you guys know how to proceed depending on the outcome of that hearing.
I have a jury trial July 8th, so I just want to make that availability. We can just anytime in July and be fine, just not last week.
Okay.
That-
No, it won't be on a regular date. I'll have to find a date for us to have some time for the hearing. Just make a notation for me and we'll take a look at it. If you'll put not July 8th week. Okay. All right. Stay in touch with Mr. Comerford. He'll let you know when you need to be back and ready for that hearing. Okay. All right. Thank you. Good morning, sir. Are you Michael Harrison Jr.?
Yes, ma'am.
This is 25 DCCR 1859. Mr. Harrison is charged with driving while intoxicated, third or more. And what is the announcement?
Your Honor, we reviewed the evidence, received an offer, and if you can give us a plea date, needs to arrange some time on weekends for.
All right. Any issues?
No, Your Honor.
You've got the ignition interlock device. Make sure you keep that, take care of that. And we'll just do a normal reset for a plea on the
Yes,
plea
Your Honor.
docket. We'll take care of it on that day. All right.
Thank you, Your Honor.
Thank
Have
you.
excuse.
Yes, sir.
Thank you.
Good morning, sir. You're Edgar Castillo.
Yes, ma'am.
And this is 25 DCCR 1052. Mr. Castillo is charged with evading arrest or detention with the use of a vehicle. And what is the announcement?
We have a deal worked out. We're gonna need to have a little time to sign everything up.
I'll hold it. You're going to do that today? Yeah.
I believe so.
Okay. Just have a seat, sir. Blaine Dunnigan, hold that.
Please, Judge.
And then Toy Frazier.
Boy. Yes, we can reset that with permission from the court.
Good morning, sir. You're Toy Frazier.
Yes, ma'am.
And this is 25 DCCR 1494. Mr. Frazier is charged with giving a false name or information or forging a vehicle registration. And what is the announcement?
Judge, we're asking for a little time on that. If we could have a normal recess, and Ms. Bonfino and I can discuss.
I would agree, Judge. This case actually involves the tax assessor director.
Yeah, I'm just looking. It looks like you were signed on in October of last year. So this will be the final reset. So make sure y'all get together, visit it. Mr. Frazier, make sure you stay in touch with Mr. Gertz. Once he gets any information, we'll get an announcement at the next court date. Okay, thank you. You're free to go. Make that notation, please. Good morning, sir. You're Davion Mason. And will your client waive the formal reading of the indictment?
Yes, ma'am.
Mr. Mason, in cause number 25, DCCR 1511, you're charged with the state jail felony offense of burglary of a building, and that's from August 18th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you made is for a 5-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenors number 1.
No objection here.
It's admitted. Is there any evidence that Mr. Mason's not competent?
No.
Is there any issue with restitution?
I have the restitution amount, but I would ask the court, please just
Go ahead and
Because
give
of my prior dealings with Mr. Mason, would you please get a PSI?
Yeah, so Mr. Mason,
$2,000. There is a co-defendant that I would make
Okay.
it incumbent upon both.
need
of
some more information on that. So, Mr. Mason, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. If there's any restitution, we'll discuss that on that date as well, okay? On your way out of the courtroom today, you need to stop and talk to the probation officer, and she's sitting at that desk right there. All right, we'll see you back at sentencing.
Thank you, Judge.
Good morning, sir. You're Lance Charbino?
Yes, ma'am.
And Mr. Charbino is charged in cause number 25 DCCR 0096 with credit or debit card abuse. And what is the announcement?
Judge, we have a resolution in place, but it's going to require some upfront restitution. So we're asking for some additional time for them to come up with that. About 30, 45 days should be enough. We have to do that.
Smoking eye?
I have no objection to that. Judge, we've offered to reduce it to a misdemeanor based on his having no criminal history. If he'll pay that up front, I believe it's about $5,000.
So here's the thing, Mr. Charbino, I'll do a 45-day reset. Give you some time. If you can get the money together, great. Sounds like that's a great deal. If for some reason you can't, I'm not going to keep resetting it for that. You guys will have to talk about some other resolution.
Yes,
okay? So do what you can, but I will give you 45 days on that.
Yes, ma'am.
All right.
Thank you.
Thank you. You're free to go. Richard Volry, it's a sentencing, Mr. Lewis and Ms. Mulvey.
We've got getting ready for this other trial this afternoon.
Good morning. You're Felicia Freddy. And Miss Freddy, this is an MTRP in cause number 24 DCCR 1390. What is the announcement?
Judge, if we could have a few minutes, I think I'll be able to get this resolved today.
Okay, sure. I'll hold
It's
it.
an MTRP, Judge. So.
Thank you. Just have a seat, ma'am, okay? And then you've got Miguel Martinez, Mr. Burks.
Yes, Judge.
So, you're Miguel Martinez. This is 25 DCCR 0584. Mr. Martinez charged with aggravated sexual assault of a child. And what is the announcement?
Judge, the state made us an offer and we have made a counter offer in the case. And I think the state needs to get input from the family, is my understanding. And so they're not saying no, they're just saying, let us check. So I don't know if you want to do 2 weeks or 3 weeks.
I'm going to do 2 weeks. It'll be the final reset. It looks like this has been about a year.
There is a possibility that I'll be in trial in Lufkin and federal court on that day, but we will let
Just
you know.
let us know and we can push it a week or two if we have to. Make sure you stay in touch with Mr. Gert so that once he visits with Ms. French, you guys know, because